Hey there, guys. My name's Andrea, and I'm here today to tell you all about negligence in schools. This is everything you need to know about how to prevent being in a situation where you could end up being liable for being negligent towards students. But we'll learn all about this in just a moment. So, why is it important? Why should you as a teacher care? Well, this topic relates to schools, and we are, of course, teachers. Schools are expected to be places that are safe environments for their students. So think about this for a second. Kids spend 8 hours a day, 5 days a week in school. That's a pretty good chunk of their day. The ATA states that there's a great interest in teacher liability for three basic reasons. School and off-campus activities are prone to accidents and possible litigation. Courts in Canada have awarded huge sums of money to students injured during school activity. And thirdly, the public's understanding of the concepts of rights and corresponding readiness to seek redress has increased. School districts, school officials, or employees may be liable for tortious acts depending on the circumstances surrounding the injury and the extent of the injury. So, what is tort law then? One aspect of tort law is to compensate a wrong party at the expense of the party at fault. And there's two kinds. We have intentional, with assault, battery, false imprisonment, infliction of mental suffering. These are all intentional under tort law. Unintentional may include negligence. So someone who's harmed may claim monetary damages for intentional or unintentional torts. They may also, under certain conditions, seek injunctive relief to prevent continuation of harmful practice. Here I've included a little visual. Negligence. What does it mean? How can it be established in a court of law? So we're going to look at these 5 steps in detail a little bit later. Was the plaintiff owed a duty of care? Did the defendant fail to exercise reasonable care? Did that lack of reasonable care result in injury to the plaintiff? Was there damage to the plaintiff? How much? Was there conduct to the plaintiff? So let's look at the first one. Was the plaintiff owed a duty of care? Well, teachers have 3 duties. They have to instruct, supervise, and provide for the safety of their students. It's mandatory that students attend school, as you know, and therefore teachers are compelled to act in loco parentis. So this is Latin for meaning in place of the parent, and this refers to the responsibility of the teacher to take on some of the responsibilities of the parent while the parent is away. This means teachers are obliged to foresee certain dangers that might cause the students harm. What do these duties include, you might ask? Well, you had to provide supervision, having closer supervision to activities that have a higher risk of injury, and you have to maintain equipment and facilities. Did you know that a teacher's duty of care might also arise from undertaking responsibilities for extracurricular activities even? So they're responsible from the time the students enter the schoolyard until they leave the schoolyard. For bus students, it's from the time that they load onto the bus till the time that they get off the bus. A duty to protect is easy to prove to the courts. However, keep in mind this may apply beyond school hours and off school grounds. Oh yeah, and the younger the student is, the higher the duty of care that's owed to them. Did you know primary students are more likely to be injured on playgrounds? Secondary students are more likely to be injured in phys ed class. Interesting. Next, you want to see if the defendant failed to use a duty of care. There's a breach of duty if the employee fails to protect a student from injury that was foreseeable. Accidents happen, but the reasonable prudent parent test will be used to see if teachers made careful and sensitive parental decisions that maintain the child's best interest. So a child with a disability will need to be supervised more closely, as we've talked about, because there's a greater potential for injury. The degree of care that should be undertaken by a reasonable teacher is determined by the teacher's training or experience, the age of the students, the type of activity, whether the supervising teacher was present, and the environment in which the injury occurred. Did the lack of reasonable care result in injury to the plaintiff? So, I'm distracted by this picture here, but Did the negligent behavior of the teacher result in the student being injured, whether physically or mentally? Well, there's two causes for this. And one is proximate cause, in which the student's injury could have been foreseen or prevented, and contributory cause, that shows the student contributed to the injury. This is a common defense against liability right here. But it's difficult to prove for children under the age of 7, like this little guy. So what happens if there was damage to the plaintiff? If there is damage, be sure to document this. Fill out an incident report and record names, date, the time, what happened, what action proceeded, and be sure to be sure to sign this document. Without proof of an injury, damage suits will be unsuccessful in this case. So take the necessary steps to ensure medical attention, and it would also be wise to advise parents as well as the principal. What was the conduct of the plaintiff? There must be no conduct on the part of the plaintiff that would preclude him from recovery. So this was taken from your textbook. For example, if the plaintiff were involved in a criminal activity at the time of the injury, this might change whether or not the teacher will be found liable. Dun-dun-dun-dun-dun! What would you do? This is a scenario here. So you are a substitute teacher filling in for a junior high gym teacher. The class is learning to play rugby, a sport you've never played in your life. Now, we all know how rough rugby is, or for those of you that don't know, it could be dangerous. So the students are anxious to play the game, but you have some concern about your lack of knowledge, and the risks you perceive may be presented if you allow the students to play. Now think about this. What is your responsibility as the substitute gym teacher? What should you do in the circumstance? Obviously, you're not feeling comfortable. And would it matter if you had taught the students previously? Think about this. Maybe talk it over with a partner if there's anyone beside you. Okay, time's up. I want to get into the 4 basic defenses for negligence. There's contributory negligence, assumption of risk, comparative negligence, and immunity. So, in a nutshell, contributory negligence is when it's demonstrated that the participant contributed to his own injuries. This could be from carelessness, using faulty equipment, ignoring warnings, or even just disobeying the safety rules in general. But these safety rules have to be understandable by a reasonable participant. Assumption of risk. This is an extremely important defense against claims of negligence, okay? So this is when a participant voluntarily assumes the risks that are inherent in an activity. The proper use of consent forms is important here, but as we know, these waivers don't completely save teachers' butts from being held liable. Comparative negligence. This is similar to contributory negligence, except if it's found that the participant contributed to his injuries, the responsibility between the participant and the professional are compared. So, for example, a jury might find that the plaintiff was 30% at fault and the defendant was 70% at fault. And lastly, we have immunity. So certain persons are not subject to tort liability. These persons might include young children. Immunity. This is the most successful defense against negligence, and also could be failure of the plaintiff to prove breach of duty. That's the most common defense. So what if there's an accident? Keep calm and follow school policy, basically. Document as many details as possible. Sign, date, and copy this document. If by chance you or the school authority is sued, it's in your best interest to go to the ATA, Alberta Teachers Association, for legal advice. You do have insurance, or you might be self-insured, as long as your actions were within the scope of employment. So you can look on page 80 to maybe check that out. Now, child abuse, you know that as a teacher that if you suspect child abuse, you have to report it, or else you will be negligent in this case. So, can you report this to parents, administration, counselors? No. Report this to the child welfare director. This part of legislation is under the Child, Youth, and Family Enhancement Act. Call 1-800-387-KIDS. But don't worry, no action can be taken against the teacher for reporting as long as it's done in good faith. So don't let that scare you. Accidents happen. Understanding the 5 principles is essential. Remember, you owe your students a duty of care. Now here I've inserted a little mock trial. I don't really have time to show you this in my slide because I don't have enough time, but basically there's the defendant, who is the teacher, and the plaintiff is a parent of one of the students in the gym teacher's class. So the gym teacher was teaching a lesson in golf when one of the students was smacked in the face by a golf club and ended up missing a few teeth because of this incident, and so the teacher's now being sued. So on your own time, I guess, if you want to take a look at this, it's pretty entertaining. I play both the defendant and the judge, and just all 3 characters basically. It's pretty funny. So these are my references. APA, alphabetical order. It's nice. Some photo references. And I have a little bit of time, so I'll just show you a sneak peek. Nope, that's not what I want. Sneak peek of the greatest show.
Thank you. Sit down. I am Judge Julie. Bailiff, what's our next case? Ah, yes. Miss Sanders? I understand you have a complaint against Mrs. Morrison. Absolutely. I'm here on behalf of my daughter Isabel, who, if not for the negligence of her gym teacher, Mrs. Morrison, she would not be in the hospital right now, missing several teeth. Now, Miss Sanders, would you like to enlighten me as to why Isabel is missing some teeth? It was terrible. I was just sitting at work and I got a call from the principal saying that my Izzy got struck in the face by a golf club. I drove straight to the hospital and Izzy told me she got struck in the face by the boy in front of her that was practicing his swing. It is important when engaged in activities that may cause a higher risk of injuries that teachers supervise more closely to their students and ensure they are aware of the dangers involved prior to participation. Your Honor, I'm aware of the duty of care that I need to provide to my students. However, I assure you that I took all the necessary precautions to ensure the safety of the students in my gym class. So you're saying you acted as a reasonable, prudent parent in this case. Let me explain. I took a course this summer. It was a 4-week course on how to teach golf. We used wiffle balls instead of golf balls, and I also went over the safety precautions prior to starting the activities. I follow you. Go on. How did this accident occur? Your Honor, I have 37 students in my class, and therefore it's very difficult to keep an eye on each one. At the time of the accident, I was on the other side of the gym helping another student. She was not helping a group of students. I bet she wasn't even at the gym at the time.